First, I'd like to say peace to the gods. Welcome to Truth Tuesday with your host, Akeem L.
He knows more than you can imagine.
Well, the truth is, you got to get yourself together. The truth is, you got to get your mind right. The truth is, you got to get your paperwork in order. The truth is, hindsight radio. I'm listening, but are they listening? Hindsight radio. What you talking about? Okay. What about Tuesday? Yo, Akeem, pick me up. You turn that on, son.
Welcome to Blog Talk Radio. Please hold and you'll be able to listen to the show.
At last. Hindsight radio. The truth is Tuesday. With your host, Akeem L. The truth.
Peace to the gods. You're listening to Hindsight Radio. This is Hindsight Radio. I represent it. The information station changing the nation.
Peace. What's up, everybody? It's another Truth Tuesday with your host, Akeem L. Here on Hindsight Radio, the information station changing the nation. Hope y'all doing great. I took a vacation last week. That's how come we didn't have a show. Last week, hang on a second. We didn't have a show because I was in West Palm Beach, Florida, chilling. Me and Beth took a break for a few days. Last week was a interesting week. A lot of stuff went down, but it turned out that at the end of the day, it turned out to be pretty good. Today we're going to talk about jurisdiction. We're going to talk about jurisdiction because there's people that say jurisdiction can't be challenged or you shouldn't challenge it because you might have, different things going on that you won't be able to overcome. I've heard this from several different people. And that comes from they listen to other people tell them things, and they don't challenge the. Okay, you telling me to do this thing. Okay, how did it work for you when you didn't challenge jurisdiction? How did it work? They never ask that important question. Never. And it's funny. And when you listen to some of this content, you're like, wait a minute. You're saying not to do something, but you're not elaborating. You're not giving details. You guys know I'm going to pull up paperwork. I'm going to pull up all kinds of stuff for you. I know I'm doing an excellent job here because they're coming at me. They're trying to attack me directly in my content because my content is it's a nail in their side. It's salt on the wound of the lies that they tell. Okay? I just laugh it off because this is like, Michael Jordan versus the Knicks type situation. Okay? Although Knicks was my home team, So I laugh because I research, I read. And one of the biggest things I do, I get into my spiritual meditations. Like yesterday, I got them. I've been talking about writing a book for a while, and I actually got up and wrote a book yesterday morning. All 4 chapters. Only need 4 chapters. When you're telling the truth, you don't need a whole bunch of pages to tell the truth. And this book is going to be so powerful, very simple and to the point. I'm not going to reveal the title until it gets published, but it's done pretty much. I probably got to do the foreword. I think I'm going to add a conclusion, but I did it in one sitting while the ancestors were talking to me. So before I get into the topic of this jurisdiction question, or not even a question, the issue of it, I'm going to actually read some case law and show you how jurisdiction is, especially that personal jurisdiction, is important to challenge at the very beginning. Hey, hang on. I didn't. I always do this or blog talk. I'm so wrapped up into YouTube and Facebook and all. I be forgetting about the treating no blog talk like a stepchild. I didn't even open the mic, so I didn't hear half of the stuff I said. But anyway, they'll get the point once I get into it. How many of you have actually made up your mind to be successful? I mean, really made up your mind. That's what you want to. You want to be successful, whether it be a business, in relationships, whatever your goals are. How have you made your mind up? And what I mean by have you made your mind up is that you have no doubt that you will be successful at whatever you're trying or endeavoring, or whatever you started. That you're gonna be successful. You may not know all of the little details, all of the the roads you might take, but the end result is your success, your wealth, your peace, your prosperity, your good health. This. That's what I mean by made up your mind. I don't mean when you want to aspire to do something and you got all these doubts in your mind. That means that you're double-minded. You see, that's what that means. That means you're double-minded. You're not sure about your success. You don't know how it's going to come, what you're going to do. That's double-minded. So you have to make it up in your mind that failure is not an option. That your success is going to happen by any means necessary without harming anyone or anything. Okay? That's what I mean. And I know a lot of people have aspirations, but they haven't made their mind up. They haven't defined in their mind and visualized their own success. I'm telling you, this mind science is real. Reverend Knight was on to something when he started talking about this mind science. Scientists are coming out, quantifying it and breaking it down in science terms, how powerful your thoughts are, and it gives you exactly what you want. So if it's something you're not liking in your life right now, that you're not totally appreciating, your thought, you gave yourself that experience. And I know so many people want to refuse that. They don't. No, I couldn't give me this. I got fired from my job. I gave myself being fired. Yes, you had a fear somewhere. When I got fired from Walmart all those years ago, I hated the job. I hated it. So I hated it so much that I tried to get a new position. And before I got that new position, I got fired from it. If I'd have gotten that new position, it would take so much time away from my home and the things I really wanted to do. So I got bye-bye. And to the point where I could never work for them ever again. I can never, if I wanted to go work for Walmart, they got me blackballed for something as simple as I tried to use my discount card on food. And I didn't know that you can't use your discount card on food. They didn't tell us that. That's what they fired me for. Abuse of the discount privilege that I never even got. But that means they wanted to get rid of me, so. But it was a good thing, because if I'd probably stayed, I wouldn't be probably doing this radio show. See, I knew I hated the job. I knew I wanted something more, and I could see it for myself. And the universe gave me exactly what I wanted by firing me, getting me and to the point where I couldn't go back. And to the point was, I was like, I'm not working for another. I was sick of it. I'm not working for anybody else that could just control my destiny like that. And that's how I got into cutting hair. I told you guys that story before. But it's a lot of little details that I didn't go into. But I really see how I gave myself that firing, how it was me that brought it to me. Because I used to get up 5 o'clock in the morning, get over there, stock them shelves, and do all that nonsense, and working with the other people who didn't. That's all they knew, and that's all they wanted out of life. They were satisfied with that little bit of money. They were satisfied being controlled, like they were on a plantation. They were satisfied, and those attitudes made me sick. Just listen at the way they was talking and behaving and the conversations. I came from Wall Street to that when I moved south. Imagine the conversations I was privy to working down at, for Payne Weber with these guys, millionaires, people making all this money, and then coming to the South and working with people who all they knew was working at either Walmart or McDonald's or some plant and thinking about their money and hourly wages, where I didn't have an hourly wage. I was on salary plus bonuses when I worked for Payne Weber and other companies that I worked for there. So, the people were great people, but they just wasn't of the same mindset that I was. I wanted more. And I gave myself more by my thoughts. They fired me, and I had to put up with like 10 weeks of no money coming in. Almost, I got the notice to be evicted. That notice said you have so many days or you're out of here. And 2 sons and a pregnant wife. Imagine that. And she couldn't work. Not a dollar was coming into that house for a while. And when I think back on that at that time, I don't even remember how I got out of it with the money. I don't remember everything, because that's how it is. When things are working for you, it'll just work. And when you go back and say, how the hell did that happen? But I'm here. But I know I made up my mind that being broke is not an option. Failure is not an option. Being an extreme millionaire is an option. That's what I'm striving for. You can call me materialistic or whatever, hey, I know one thing. When you have lots of loot, you can do lots of things, good things for people. I give to people randomly, whether it be through my tips when I'm at the restaurants, or I just see people at the side of the road holding up signs. I hand them some money. And when I give it to them, I say, may this come back to me tenfold. And it happens all the time, like clockwork. I know people who have given to this ministry. Someone gave something today. Right before the show. I know that every time this brother gives, he's getting that back 10 times. I know he can testify to that. That's why the Bible says it's happy to give than it is to receive. I don't ask you guys to help because I want to, take your money and, and blow it or, live good. I ask you because I tell you that because there's a spiritual science behind it. Reverend Knight was right. When you give and then you put a demand on that money to come back to you tenfold, it will come back. I did that last week. I gave a nice tip to someone. And I said, in my mind, I said 10 times. And it happened. All the time, like clockwork. And sometimes I got to get on my case because sometimes I get so caught up in other things, I don't remember these principles. But if I just practice this principle, if you guys just practice these principles on a daily, and not just daily and multiple times throughout the day, you know how rich you will be if you just practice that. Nothing anybody can do to stop you. There's people the other platforms, they don't want me telling y'all the truth. They don't want me to tell you that this whole secure party creditor stuff is a bunch of nonsense and y'all just wasting money. They don't want me to tell y'all how to go through these courts and know the procedure, know their game, and know the loopholes in their game. And one of the biggest loopholes is constitution and jurisdiction. Personal and subject matter, those two right there. And when I read these cases this case to you, I'm going to prove to you how important jurisdiction is. And you need to be asserting it. Even if you don't. See, people say, if you don't know what you're doing, minimum contacts this, you shouldn't be doing that. No. I'm going to tell you, even if you don't really fully understand what jurisdiction is, you need to be saying it because of one thing. They got to tell you how they have jurisdiction. They have to make it clear. That's why in every petition, there is a clear outline of how that court has jurisdiction to make a decision. These people are not reading cases. They say they're reading it. They either they read it and can't comprehend, or they're deliberately telling y'all something false. You see? So back to the whole, have you made up your mind for success? Have you made up your mind to be the person that you say you want to be? No doubt. You got to get rid of all doubt. That's like being lukewarm. And the Bible says you be spit out. Lukewarm, either you're hot or you're cold, one or the other. Who's in the chat? Let's see who's supporting today. A lot of people. Jamie, what's up? Peace. Curtis Williams, Karen Israel, as always. Amexa Moore, peace. Thank you for the donation. Marnell Bay, peace. DJ B Thunder, peace. Chief Lemuel, Carter A, Yokub Malik Bay, JDL, Slaw Shaw, Shalom. Who else? Antonio L. And all those who are either on Blog Talk listening in right now is nobody. Everybody's on YouTube. Yeah, so hey, that's right, Karen. The only person that can stop you is you. That's it. No one else is. See, we have to understand how that mind works. People do say and try things all the time. Now it's up to you to make a contract with their words and accept them as truth. The only reason why you don't know who you are, or most people don't know who they are, is because they don't understand their true power, and their power is drawn off of someone else's idea of who they should believe in and what they should do. This is why it's so easy for people to go and allow entities to tell them what to take for their health, because they don't know, or they have not taken the time to study their own Bible. They not haven't taken the time to study their own health. Because if you study your own health, there's so many things out there that can help you. I just ordered some golden seal. Very powerful detoxifier. Some people use it to get you past drug tests. Yeah, really. But there's other things that can help you pass drug tests. Just my little side note. Apple cider vinegar helps get rid of marijuana, if you're taking a piss test. Cranberry juice is for the white stuff. Okay, that came straight from a doctor, because the chemical basis of those two things combine with chemical of those drugs, and you will urinate them out. Now, if they do a hair follicle test, you're done. You're not getting around that. So, but if you a urine test, those two things will help you. So that might help some people out there who trying to get a job and they got to take a drug test. All right. So, but yeah, Golden Seal, very good. What is it? Antibacterial herb that you take, and it's very expensive. Like a pound of it was almost $100, but I bought it. It's good to have it, man. Y'all should see my my cabinet full of. Let me see if I can pull up a photo of my my cabinet of herbs. All right, let me share this. All right, now they be asking. Okay, window. Let's see which window. Chrome tab, window, photos. Hang on, they. I got this new computer and I gotta do some. All right, let's see what I want to share. This right here. There it is. That's my apothecary. That's just some of them. That's just some of them. There you go. That's a little bit. That's a African bird pepper, turmeric. Oh, let me see if I can. So I can read the labels. Hyssop herb, sarsaparilla root, flaxseed, burdock root, licorice root, small flowered willow herb tea, beetroot. That's good. Small flowered willow herb is good for gray hair. And y'all can tell I ain't been taking it. Parsley root. I don't plan on getting rid of my gray hair. Mullein leaf, very good for anything to do with the lungs. And golden seal is good for that too. Yeah. Let me get me some this is my water that I distill. I'm not trying to advertise for nobody, so they're not paying me. Unless they're paying me, I ain't showing they label. Um, that's right. Hit the like buttons for me. Got 14, we got 40 in the building. Come on, we can do better than that. Good people. Study more peace. Apple cider, if you want to mess with it, I say not the butt, the guy, and just a couple of teaspoons. I poured it, just letting you know. I don't know. I'm not sure what you're trying to say. Yeah, I know not to take that more than 7 consecutive days. Peace. He said apple cider is poison. I don't know about that. So is turpentine, but mixed with sugar, it does wonders for the body. Oh, I know everybody's got their things what something is good or not good, but apple cider vinegar is very good for people who have high blood pressure. That's true. So I don't know. I never heard that apple cider vinegar was poison. You're the first one that I've ever heard that from. Dr. Daniels is a doctor. Plenty of other doctors always suggest apple cider vinegar. All right, let's get into this whole jurisdiction thing. Let's get into that. I'm going to pull up this case. Oh. Now, who would be calling me while I'm on the phone? While I'm doing my show. I don't know. It's not a number I'm familiar with. Let's see. Where's my case at? Okay, here it is. The case is Charles Thomas Dickinson petitioner versus United States. Let's share this so y'all can see this. All right. Let's share this. Share screen. And I want Chrome tab Dickinson. Boom. Y'all can see that. Let me fix up some windows here. Chat. All right, there we go. They take some banners away. Hide that. This is Charles Dickinson case. So let's read this case. And it's really pertaining to the Miranda warnings and things like that. So this is how, this all ties in with the jurisdiction thing. In Miranda v. Arizona, we held that certain warnings must be given before a suspect's statement made during custodial interrogation could be admitted in evidence. So what's a custodial interrogation? What's a custodial interrogation? Let's look that up. Let's look it up. In the United States criminal law, a custodial interrogation or generally custodial situation is a situation in which the suspect's freedom of movement is restrained, even if he is not under arrest. So, what's examples of this? What is an example of a custodial interrogation? Wouldn't a traffic stop be an custodial interrogation? Oh, before I keep going, hey, I am not an attorney. This is a ministry. Hindsight is a ministry. It's the Ministry of Infinite Abundance, the Church of Infinite Abundance, and the Akeem Barber Church just gives spiritual counsel. As a matter of fact, on the screen there's a lawyer there. You might want, if you feel like you need one, there's some numbers. One is criminal law, one is personal injury, family. There you go. But what's a custodial arrest? A traffic stop is a custodial interrogation, not arrest. Now, you hear a lot of people on YouTube, oh, that's a custodial arrest. That's not the right term. It's a custodial interrogation. Why? Because you can't leave. They're not allowing you to move. They haven't put you under arrest. That's why I see videos, oh, you got me under custodial arrest. They're totally wrong. It's custodial interrogation. Right here, Supreme Court is telling you this, okay? In the wake of that decision, Congress enacted 18 U.S.C. Section 3501, which in essence laid down a rule that the admissibility of such statements should turn only on whether or not they were voluntarily made. So when an officer pulls you over, he comes up to you, let me have license registration. What is he doing with that? He's conducting an interrogation, and he's investigating so he can look it all up and see who he's going to charge. So if you give him the stuff he's asking for voluntarily, you're giving up rights. You're giving them personal jurisdiction. Yes. But even then you have a way out. Why? Let me keep reading. Right? Ruled that admissibility of such statements should turn only on whether or not they were voluntarily made. We hold that Miranda, being a constitutional decision of this court, may not be in effect overruled by an act of Congress. And we decline to overrule Miranda ourselves. So they're telling you that act of Congress, they cannot make a law to overrule this. There's no law, and they're not going to do it. The Supreme Court I'm talking about. We therefore hold that Miranda and his progeny in this court govern the admissibility of statements made during custodial interrogation in both state and federal court. So this applies to both. So you can use this in your if you get in these traffic tickets. This is a case you can use right here. Charles Thomas Dickinson petitioner versus United States. Petitioner Dickinson was indicted for bank robbery, conspiracy to commit bank robbery, and using a firearm in the course of committing a crime of violence, all in violation of the applicable provisions of Title 18 of the United States Code. Before trial, Dickinson moved to suppress a statement he had made at Federal Bureau of Investigation field office on the grounds that he had not received Miranda warning before being interrogated. So when a cop walks up to you and start asking you stuff, all of these questions, how fast you going, all this, and he has not Mirandized you or gave you a Miranda warnings, as this states in quotations, you have an option to suppress anything you do after that point. The district court granted his motion to suppress, and the government took an interlocutory appeal to the United States Court of Appeals for the Fourth Circuit. That court, by a divided vote, reversed the district court's suppression order. It agreed with district court's conclusion that petitioner had not received Miranda warnings before making his statement. But it went on to hold that Section 3501, which in effect makes the admissibility of statements such as Dickinson's turn solely on whether they were made voluntarily, was satisfied in this case. And then concluded that our decision in Miranda was not a constitutional holding, and that therefore Congress could, by statute, have the final say on the question of admissibility. Because of the importance of the questions raised by the Courts of Appeals decision, we granted certiorari, and now reversed. So they reversed the decision back. One court said, yeah, he did it voluntarily. We're gonna we reversing that decision. We begin with a brief historical account of the law governing the admission of confessions. Prior to Miranda, we evaluated the admissibility of suspects' confession under a voluntariness test. The roots of this test developed in the common law as the courts of England and then the United States recognized that coerced confessions are inherently untrustworthy. So when you're coerced, we're going to take you to jail, we're going to do this, you better give me this, and all of that, you can use all of that to your benefit. Now, here's all of the cases. We're not going to. This one case, Lord Mansfield, CJ, stating that the English courts excluded confessions obtained by threats and promises. King versus Warwickshire. A free and voluntary confession is deserving of the highest credit because it is presumed to flow from the strongest sense of guilt. But a confession forced from the mind by the flattery of hope or by the torture of fear comes in so questionable a shape that no credit ought to be given to it, and therefore it is rejected. Let me slow down. So all of these people telling you, if you can't, don't challenge jurisdiction because you don't know how this, I'm showing y'all how. I'm not going to tell you not to do something and then don't give you the information to help you get out of it. And I think that's very irresponsible. Anybody would tell you that. Here it is, right here. Most situations you find yourself, they're threatening you. They talking about contempt of court, all of these crazy things. They get you to bow down. It's untrustworthy. And pretty soon we're going to get into vacate void judgments because just about all of these you could go back and vacate judgments that should have been voided, that shouldn't have been rendered in the first place. All right, let's keep going. Over time, our cases recognize two constitutional bases for the requirement that a confession be voluntary to be admitted into evidence. And you notice they're talking about the Constitution, right? The Fifth Amendment right against self-incrimination and the Due Process Clause of the 14th Amendment. See E.G. Bram versus, example given, Bram versus United States, 168 U.S. 532, 42, 1897, stating that the voluntariness test is controlled by the portion of the Fifth Amendment, commanding that no person shall be compelled in any criminal case to be a witness against himself. So when they're telling you, give me this, that, and that, you're in a criminal matter. You cannot be compelled to be a witness against yourself. So when they write you a ticket, well, failure to give up driver's license, failure to give a registration, you're within your rights because giving them anything is being a witness against yourself. He don't have a warrant to require that. Well, he says, well, I got probable cause. Okay, you got probable cause. Well, take your probable cause to a judge and swear under oath to your probable cause and come back and talk to me. But I'm not going to argue that on the side of the road. I'm just going to tell him, no, do whatever you got. Write me a ticket. I'll see you in court and deal with it. And then I know a lot of y'all like these tort claims working with. I'm moving towards those too. Now, Brown versus Mississippi, reversing a criminal conviction under the Due Process Clause because it was based on a confession obtained by physical coercion. What's physical coercion? When they pull out the handcuffs, right? Oh, you see? When they throwing you up against cars and stuff, those are physical coercions. While Brown was decided before Brown and his progeny for the middle third of the 20th century, our cases based the rule against admitting coerced confessions primarily, if not exclusively, on the notions of due process. We applied the due process voluntariness test in some 30 different cases, deciding during the era that intervened between Brown and Escobedo versus Illinois. Those cases refine the test into an injury that examines whether a defendant's will was overborne by the circumstances surrounding the giving of a confession. Sinekloff 412 U.S. at 226, the due process test takes into consideration the totality of all surrounding circumstances, both the characteristics of the accused and the details of the entire interrogation. All the circumstances attendant upon the confession must be taken into account. If all the attendant circumstances indicate that the confession was coerced, or compelled, it may not be used to convict the defendant. Determination depends upon a weighing of the circumstances of pressure against the power of resistance of the person confessing. Stein v. New York, 346 U.S. 156 85 1953. We have never abandoned the due process jurisprudence and thus continue to exclude confessions that was obtained involuntarily, but our decisions in Malloy v. Hogan and Miranda changed the focus of much of the inquiry in determining the admissibility of suspects' incriminating statements. In Malloy, we held the Fifth Amendment self-incrimination clause is incorporated in the due process clause of the 14th Amendment and thus applies to the states. At 6-11, we decided Miranda on the heels of Malloy. So in Miranda, we noted that the advent of modern custodial police interrogation brought with it an increased concern about confessions obtained by coercion. Because custodial police interrogation by its very nature isolates and pressures the individual, we stated that even without employing brutality, the third degree, or other specific stratagems, custodial interrogation exacts a heavy toll on individual liberty and trades on the weakness of individuals. We concluded that the coercion inherent in custodial interrogation blurs the line between voluntary and involuntary statements and thus heightens the risk that an individual will not be accorded his privilege under the Fifth Amendment, not to be compelled to incriminate himself. Accordingly, we laid concrete constitutional guidelines for law enforcement agencies and courts to follow. Those guidelines established that the admissibility in evidence of any statement given during custodial interrogation of a suspect would depend on whether the police provided the suspect with full warnings. These warnings, which have come to be known colloquially as Miranda rights, are: a suspect has a right to remain silent, that anything he says can be used against him in a court of law, that he has a right to the presence of an attorney, and that if he cannot afford an attorney, one will be appointed for him prior to any questions if he so desires. They will appoint him. They're supposed to appoint you somebody. If you ask, before I say anything, I think y'all heard that, right? Now let's go to the law, which is 18 USC section 3501, admissibility of confessions. In any criminal prosecution brought by the United States or by the District of Columbia, a confession as defined in subsection E hereof shall be admissible in evidence if it is voluntarily given. Before such confession is received in evidence, the trial judge shall, out of the presence of the jury, determine any issue as to voluntariness. So let me stop right there. In places like Georgia and some states, they want you to sign the ticket, right? Now, I wouldn't sign my name. I would say under duress, involuntarily signed. I would say that. Involuntarily signed. I would actually sign it like that. Now, they might take that as your signature, but when you go to court, say, look, I wrote this involuntarily signed, so I didn't agree to nothing. I was threatened with jail or something. This just showing you how illegal these cops are behaving when they do stuff like that. They are showing you how illegal when the state tell you to sign a traffic ticket. What are you signing it for? Why am I signing something? What am I agreeing to here? I don't agree with none of this. You can say, I don't agree. Or you can put no contract. But I'm talking about being more specific. I don't agree. That's my signature. Involuntarily signed. That would be my signature. And sometimes these cops get so bold, they'll try to Hang on. I don't think I switched over to the screen. Hang on. Let me go back and share the right screen to the screen I was sharing. Share Chrome tab. This one. Share. All right, there we go. That's what I was just reading. Before such confession is received in evidence, the trial judge shall, out of the presence of the jury, determine any issue as to voluntariness. So you need to be bringing up all this stuff before y'all go to any type of trial. Right at the beginning, hey, we need to squash anything because here's why. All this was involuntary guilt. Here's the case law that supports it. Boom, bam. Okay? If the trial judge determines that the confession was voluntarily made, it shall be admitted in evidence, and the trial judge shall permit the jury to hear relevant evidence on the issue of voluntariness, and shall instruct the jury to give such weight to the confession as the jury feels it deserves under all circumstances. The trial judge, in determining the issue of voluntariness, shall take into consideration all of the circumstances surrounding the giving of the confession, including the time elapsing between arrest and arraignment of the defendant making the confession. If it was made after the arrest and before arraignment, whether such defendant knew the nature of the offense with which he was charged or which he was suspected at the time of making a confession. Whether or not such defendant was advised or knew that he was not required to make any statement and that any such statement could be used against him. Whether or not such defendant had been advised prior to questioning of his right to the assistance of counsel, and whether or not such defendant was without the assistance of counsel when questioned and when given such confession. The presence or absence of any of the above mentioned factors to be taken into consideration by the judge need not be conclusive on the issue of voluntariness of the confession. In any criminal prosecution by the United States or by the District of Columbia, a confession made or given by a person who is a defendant therein, while such person is under arrest or other detention in the custody of any law enforcement officer or law enforcement agency, shall not be inadmissible solely because of delay in bringing such person before a magistrate, judge, or other officer empowered to commit persons charged with offense against the law of the United States or District of Columbia, if such confession is found by the trial judge to have been made voluntarily. And if the weight to be given the confession is left to the jury, and if such confession was made or given by such person within 6 hours immediately following his arrest or other detention. So they even said within 6 hours. That the time limitation contained in this subsection shall not apply to any case in which the delay is bringing such person before such magistrate, judge, or other officer beyond such 6 hour period is found by the trial judge to be reasonable considering the means of transportation and the distance to be traveled to the nearest available such magistrate, judge, or other officer. You know, this C section is telling you that when you get arrested, you're supposed to go straight to a judge. That's basically what it's saying. I think y'all get the point, right? Y'all get the point. So why would you listen to anyone tell you don't challenge jurisdiction because you might have some minimum contact somewhere? What? This ain't say nothing about no minimum contacts. Yeah, maybe you getting charged with something because you're using a social or whatever on some things. That still doesn't mean you can't challenge jurisdiction. You know, everything is commerce, everything is admiralty, and all of this BS, man. When y'all gonna get it through y'all skulls that stuff didn't work before and it ain't gonna work now? The one thing that courts got to adhere to is jurisdiction. And that's all it is. They don't have it, they can't make a ruling. It's the one thing that gets you avoid judgment. If no matter whether you did it or not, they gotta establish that jurisdiction. That's why they call, are you such and such? And you go in there answering to that. That's personal jurisdiction. Showing up to the case is personal jurisdiction. But yeah, but if you have your motion to dismiss in there before you answer, that's not giving jurisdiction. I had a situation where he didn't answer, and no answer is acquiescence, and I should win the case. And I simply point out, I actually wrote this. Is the attorney so uneducated that by me doing this motion to dismiss is showing the court that it don't have jurisdiction? And this is why I'm telling them to dismiss it, because there's no jurisdiction here. I'm not giving all of the specifics. So by me answering, would say the whole basis of this dismissal is about jurisdiction. So why would I answer something why would I go into the controversy when I don't need to talk to them about the problem or what was or wasn't. All I'm saying is you guys don't have jurisdiction for us to even have a conversation. So until we figure out whether this court has jurisdiction to move forward to even decide the matter, or even before it could go to a jury, we need to figure out the jurisdiction part. Okay? Stop listening to these people. The court needs that to make decisions. And if you take that from them, they can't make the decision. So start there. Why jump into all of this? I got my UCC filed. I'm not the straw man and all of that. I was served improperly. Well, you can say that too, but you need to put that in your paperwork. That's jurisdiction too, and proper service. Y'all looking for this guy. I can't even read this thing y'all got on here in all caps. I don't know what that said. I don't understand that. I understand this. I understand this, what I wrote, but I don't understand what y'all got. That's why if you ever sit in a traffic court and someone, they agree to some, you were speeding 100 in a 70. Well, we're going to knock it down to 10 miles over. Fine is $100. We're going to give you this break. And then they go to the so-called defendant and ask, we agree. And he might go on, he might grunt. And then the judge say, do you understand? And he grunts again. And hey, do you understand? That's jurisdiction. He can't make a decision until you voluntarily say, yes, you understand. So what are you talking about? Minimum contacts. What are they talking about? You know what? This is a warning because I see the attacks coming. I'm telling y'all, I ain't going to do what I did 2 years ago. I'm going to respectfully pull out the real cannons and show y'all the truth. Okay, you saying this? Okay, here, what's this here? I'm gonna really start pointing this stuff out. So there's your warning to all of those who think they want to come at me. I'm ready. I was ready before, but the Spirit said not to do it. Now the Spirit's saying it's time to wage war on these people who's robbing y'all of y'all money. Now, that the only warning is go back into your little corner and teach whatever y'all want. Leave my name out of it. Do it. Go do y'all thing. Leave me. I mind my business. You mind yours. But if telling y'all, drop these nuclear weapons, hey, now, because this is dangerous to tell someone not to challenge jurisdiction. That is very dangerous. Because once you move on to the controversy, it's almost irreversible to get out of whatever they rule on you. I've seen it work. I've had people sitting there in trial crying, jurisdiction. You don't have subject matter. You don't have personal. And they're not explaining it. And then they still went home looking at time, and they went home. All because they challenged jurisdiction. And they had minimum contacts. They had more than minimum contacts. All right. They get me heated with this nonsense, these lies. So does the do not detain list not apply here? What do you mean do not detain list? Y'all see that's something repeated from somewhere else. How do you know there is a do not detain list? Yeah, I suspect there's one. I've never seen one. I know that when I do my paperwork correctly, they don't really bother me. And other people that have done certain things, they don't really bother me. Now, this whole do not detain list is not something I've ever seen. I heard people perpetrating that. They're going to put you on a do not detain list. Well, I tell you what, tell them to show you that you on a do not detain list. See, you'll never hear something come out of my mouth that you will be on some type of special list. What I will tell you is, since I've done this, this is how I've been treated. I don't have evidence of a do not detain list. Never seen one. So signing all rights reserved. Yeah, signing all rights reserved without prejudice is good. That's fine. But when I'm dealing with a traffic ticket situation where they're trying to get me to sign the traffic, I'll be saying it involuntarily signed, and that's all I'm writing. Right there, involuntarily signed. That is clear. So when the judge looks at that ticket, he said involuntarily signed here. Not the all rights reserved. Yeah, I mean, if you want to write that, that's fine. But I think being clear and more precise in your dealing with them is more beneficial than that. Now, when I tell y'all how to do y'all passport process, I tell you to sign that. All rights reserved without prejudice. Yeah, that's fine. When you're doing something like that. And if they proceed without giving no respect to listen, they have proceeded without giving respect to jurisdiction. See, what y'all want is y'all win right there on the spot. What happens is they go through their little fake stuff, and then next you know you walking out, oh, this, that, and the other. I think guy went through a straight up trial, looking at 10 years, and he's walking around and was found guilty. And all he did was say, he didn't go back and forth with them. Hey, y'all don't have jurisdiction. And this is why he kept saying that over and over again. And he walked out of there. So they did their little mock trial. Okay? So they play games. If I confess is done to the police, are they a new priesthood? What are you talking? I don't know. You got me lost there. I don't know about no priesthood and all that. That sounds like something. I think that's a question for where you got that information, the priesthood stuff. I think that's better question for wherever you heard that from. Ask them that. You never heard, no one ever heard me talking about priesthoods and Vaticans and the Catholic Church and England. You don't hear me. I don't talk like that. I talk in the area of their rules and taking their rules and using them to my advantage. There you go. They lay claim to, see, that's more, you're in custody and they question when you can't leave, you are in custody. Yes, that's a custodial interrogation. See, somebody's putting up there. They're not trying to heed divine law. They want to hear the Pope's law. See, all that stuff is good knowledge to know, but it's not good to use to defend yourself. Okay? Because everything is about evidence. And you want to go get the Pope law and all of that and use that in your case and try to win it, it ain't going to work. All right? I'm going through the question. All right. Since in every case indifferent at their mock trial, not saying anything else, just saying on jurisdiction, not moving off of that, would a person be thoughtful to look for a curveball? Yeah, you can look for a curveball, but I'm not moving off jurisdiction. Simple. That's simple. Hey, if y'all got a question or a comment, there's the number at the bottom of the screen, 563-999-3615. 563-999-3615. You want to chime in on this jurisdictional talk, you can. call me directly. I'll get your call. If not, I'm out. I think I'm tired. I didn't take a plane there. We drove. So 9 hours driving to Palm Beach. Nice John D. MacArthur State Park. Very nice park. Little oasis we found on our last day of relaxation. How do you request 288C? What is that? What's 288C? 288C. Is that an IRS code, exemption from property taxes? I don't know. Don't know. If that's what your question is. I haven't got to that part yet. Which jurisdiction? Personal jurisdiction, subject matter jurisdiction, mostly in the beginning, personal jurisdiction. Do y'all have the right person here? I'm not a who you say I am. Yeah. Do they make presumptions? Yes, they do, but it's your job to get rid of them. See, the only reason why they presume because you haven't put in a notice of appearance when you walk in there. Don't all attorneys put in a notice of appearance who they're going to be representing? They put a notice of appearance. Why? How come you can't do that? And put it in such a way that they're clear that you're not the entity they're looking for, and have that on a record. And even go so far as say take judicial notice of that. Let's get those there. Yeah, that's right. Get the likes up. If you challenge jurisdiction, they have it. Can you challenge how they got how first of all, see, that's the thing. JDL, you're saying if you challenge us and they have it, how do they have it? In most cases, they don't have it. See, the issue you have is you don't know what jurisdiction really is, how it works. That's why you're asking that question. Jurisdiction is gained by your voluntary submission, showing up to the court and answering and giving an answer to their claim. Putting a motion to dismiss is not giving them jurisdiction. Because why? You're going to put a motion to dismiss saying that they don't have jurisdiction, and here's why you don't have jurisdiction. You didn't have a warrant. You didn't have all of these things in place. So how do they have jurisdiction? See, that's what y'all have to look at. Yeah, some of y'all are so blinded by this other garbage out there, y'all can't see how simple it is. None of this stuff is complicated. It's complicated because so many people are saying so many different things, and most of them are not talking about jurisdiction. They're talking about UCCs and commerce, do accepted for value, and all these other books that they're reading, creditors in their bond, and use all of this stuff that has never worked. If you're not a U.S. citizen and that's what they want in the court, then and you state that you're not that. Does purchase involve the styling of the party's name? Yes. If they got your name styled improperly, then it's not you. I won a case just on that. Showing, hey, this is not me. How they got this? This styling is wrong. Case dismissed. Evidence can be challenged at any point. It's called subject matter jurisdiction. So if the evidence they use is not supported by oath and affirmation or somebody with firsthand knowledge, a competent fact witness, and it can't be the cop, then yes, you have a basis to challenge jurisdiction under the subject matter jurisdiction. Yes. You can have what you call a vacate void judgment because the judge entered a decision without having a competent fact witness, signed affidavits, all of that. A ticket is not a signed affidavit because who notarized that? Okay. What they do is they go and write you a ticket, and then they go and write up some notes. Those are not, where's the signed affidavit? Where is it? There is none with a traffic ticket. And that's what, to render any judgment, that's what you need. You need a sworn statement. Because that's evidence. Him just saying something is not evidence. That's hearsay. Did you ride your bikes? What is he talking about? I don't get that question. I put restricted appearance and a motion to vacate the default judgment. The judge muted me and yelled over me and ended the Zoom hearing. They always do that. When you start hitting them with the right stuff and they cut you off the Zoom hearing, that means you're doing something right. Then they reschedule it. So that means you keep doing what you're doing until they leave you alone. I've seen that happen when people start saying challenging jurisdiction, and then they point out certain things. Either they'll, some judges are very polite, so they'll say, okay, we're going to reschedule this matter, blah, blah. Then they'll say, well, you need to get an attorney. That's the, encourage, make you think you're wrong. Because why? If you got an attorney now, that attorney's going to be your power of attorney, and he's going to speak for you, and he's going to give them jurisdiction. Because what he's going to do is argue the matter. Once y'all start getting to the controversy, personal jurisdiction is waived right there. Boom, gone. But subject matter jurisdiction, you can still fight that. You think evidence can be challenged at any point? Yes. Good info right now is appreciated. Charles Sprinkles versus Ronald Reagan, 1975. Not sure what that say. I'm not going to look it up right now. Oh. Okay, let me see who I got on the phone lines. Look like some people out there. Yeah, we do. We have a couple. Let's see. 682-232. Peace.
Peace to the gods. Grand Rising.
Grand Rising, brother. How you doing?
Wonderful, wonderful. I just had a real quick question on this. If you can answer it here, or would I have to get a what is it called?
Consultation?
Yeah, consultation.
I might be able to answer it. What's the question?
Well, it's into answering some interrogatories on challenging them with jurisdiction. An attorney was sent some paperwork, and jurisdiction haven't been given yet because none of the answers have been responded to. But I was sent some paperwork from the Superior Court of this particular state, and they sent me 4 various documents that's already on the docket or whatever, where it's answers. It says assigned for special purposes and limited jurisdiction right now because it hasn't been answered. Anyway, the 4 title, one it says answer to special interrogatories. The other one is answer to form interrogatories, and then response to request for production of documents. And then the last one is response to request for admissions. My question to you would
those
be,
are all discovery questions and stuff like exactly. That. It sounds like.
Yes.
Yes. Now, look, okay, they're sending that to you, or you sent that to them to answer.
No, they sent it to me to via an attorney, but I'm not dealing with the attorney. I haven't answered anything with the attorney or yet. The attorney's been calling me trying to get me to answer this stuff.
No, I wouldn't.
Basically,
you can just basically whatever questions they answered. I don't know specifically what the questions are. Is a way to respond to them and let them know you're not answering those questions. You don't have to. Mm-hmm. Now, okay, What type of case is this? Sounds like a foreclosure case or something.
No, it's an accident with a insurance company, but the insurance the guy is trying to get more money out of the insurance companies. Now, I believe, this is just my belief, that the attorneys for both insurance companies are just trying to basically make some money because now that because it happened on private property, the accident. And
so that means police didn't write a fault ticket on anyone because they can't.
No. And so basically now that the insurance companies are basically one with each other. It's two major insurance companies, and the attorney for my particular insurance company, or whatever the case may be, is wanting me to answer these.
Okay, so your insurance company attorney that works for the insurance company wants you to answer those questions.
Yeah.
Okay.
To admit, because there's a lot of things on here to say admit to this, admit to that.
No, all you gotta do is say deny.
Okay.
Admit is just a way to trick you into admitting. So when you say admit, no, I deny. I deny. If it's something that you feel is gonna harm you, you say I deny. Yeah.
Okay. Well, yeah, because he had already pre-filled these out before I even got them.
But I don't know what it says. So some of that stuff he's asking you could be helping you. I don't know what that says. So I would suggest let's do a consultation and let me look at the questions.
Okay.
Because he could be, if he's working for your insurance company, he's damn sure trying to keep from paying this other company. So those questions that he wants you to admit to could be helping you. I don't know. Without reading that, I can't tell you what that says.
Absolutely. Well, I'll put in for the.
It sounds like he's trying to get you to admit to something that's going to help them win. Because you could say, admit that you didn't hit this car. It could be one of those questions. I'm almost sure it probably is a question they're asking you that. Admit that you did not hit this car. You're not at fault. Admit that you're not at fault. He's kind of what you call. They call it.
Well,
it's a term for that.
That I am at fault. That's what it's.
No, then you say no. I deny. No, I don't admit guilt. No, I wouldn't do that.
No.
Yeah, I don't know what he's. But without seeing that, I can't really tell you exactly what it says.
Absolutely. And if I wanted an hour of your time, I just pay double.
Yeah, you just buy two of them and then schedule them. Yeah.
Okay. That's what I need to know. Because I really would like to speak with you for at least an hour, brother. All
right, because what happens when you don't cooperate with your insurance, sometimes they'll just turn on you and
absolutely.
And then they'll give the person the money and then they're gonna raise your rate or cancel you. Yeah.
Okay, because the adjuster tried calling and this, that, and other. So, all that. They're getting antsy now.
Okay. All right.
So okay. Well, I appreciate
all right, brother. Thank you.
You're doing it once again on this channel. You're doing an amazing job. Blessing to you, brother.
All right, thank you. Peace. All right, peace. Good question though. Before I get to the next call, somebody said once a judge told, let me put it up here. Once a judge told a relative of mine he cannot dismiss a legal aid they assigned to him in a family court case when he wanted to represent himself, I guess, in pro persona, she straight up told him no. Well, it ain't. Listen, all you got to do in a situation like that, when you get there, you just say, whoever believes they represent me, you are hereby fired. You're fired for the record. Right there, 3 times in the court, right there. And that's it. You don't get permission. You tell him he's fired. Right there on the record. And I guarantee you all proceedings going to stop and they're going to try to come back again with the same person. You keep doing that. Every time they show up, you're fired. You're fired. You're fired. You have a right, according to the Constitution, to represent yourself or get an attorney. They can't force you into a contract without your signature. That's why when you go get these legal aids, they make you sign off on it. All right? You're fired. You're fired. You're fired. You're fired. Y'all got to get bold. If y'all want to listen, here's the problem. Some of y'all want. Now I do understand. Someone said a lot of y'all want to do stuff, but y'all not really ready for it, and that's true. You want to go in there and say you want to represent yourself, but you're not fully prepared to even represent yourself. You don't even understand how the courtroom work. You don't understand that they can't force you into a contract, and you just no, I'm not going to do it. No, just say you ain't got to actually just tell that person they're fired right there in the court on the record. You're fired. You're fired. You're fired. You don't work for me. What the hell is amicus curiae? I don't know what that is. That's a new term for me. I don't understand what's the take on presenting yourself as amicus curiae. What is that? Y'all coming up with some first time let's see what that says. What does that mean? An impartial advisor, often voluntary to a court of law in a particular case. I don't see how that would help you based on this definition. All right, let's go to the next caller. 786-597. Peace.
Peace to the gods, Hakeem. How you doing, sir?
I'm doing good. What's going on? Good.
Hey, I'm just hanging in there. I came across something when I was looking at this child support case I'm still fighting, and
did you listen to
that,
I think the week before last show?
Yeah.
Okay. Go ahead.
The reason why I called today because I see some inconsistency in regard to like the styling of the cases. They put my name in all caps in the caption, but in the body it's not in all caps. So I'm like,
the trickery because they're addressing you in your proper form because they want you to agree to represent the improper form. So you got to point that out.
Okay. Yeah, I figured that was.
They're making you responsible for that entity. I've seen that. They in the body, they got you properly styled, and then up in there they got all of and then somewhere in the body, somewhere else, when they reference like what you owe, like say if it's an amount, they want to say, well, such and such owes this, they'll have that in all caps. But when they're making general references to you, like such and such lives here, this and that, they'll have you in up and lower. But when they start talking about the account specifically, what you owe, what you defaulted on, and they'll have that in all caps, that part. So they've gotten a little slick with that.
Yeah, and another thing that I noticed is that the attorney for the state was making all these claims and stuff on the complaint, but I don't see
that's where you're supposed to shut them down. Say you don't have firsthand knowledge. Who are you? Like, you're testifying. Are you testifying to the? You say, excuse me, objection. Unless he's gonna testify here today, he can't give testimony here without sworn testimony. He can't do that because the judge is going to use what he says to make a decision against you, and judge can't consider that. Like, wait a minute, I need sworn testimony here to testify. You see?
Okay. Yeah, I was going back and looking up the court the court case, and some of the information that's been like redacted for like so-called personal information. I'm like, okay. I'm probably gonna have to get a consultation with you so I can go into details of the.
Okay, bro.
So I'm gonna do that.
All
right. Thank you.
All right. Peace. Yeah, friend of the court. I've heard that friend of the court, and I know someone who actually tried that, and guess what? They got kicked out. So no, I don't support that. It didn't work. All right, let's go to 843-597.
You can hear me? Hello?
Yes, I can hear you.
Oh, what's up, man? Appreciate you having me on.
No problem, brother. How can I help you?
I mean, I got a question. It has to do with the topic jurisdiction. Actually, I just missed a couple court cases last week
Mm-hmm.
because I pretty much forgot about them.
Mm-hmm. What
One of
type?
them
What type case?
dealing with traffic. One of them was like a felonious false DUI that they don't, you know what I mean? This is some random things
So
that
they probably got a
not
warrant out on you
traffic
now.
stuff.
Go ahead.
Well, they sent something in the mail which reminded me about it, and it was just basically saying that I had another hearing coming up that I was gonna have to basically come to. That was like a sentencing hearing. So they don't have no warrant or nothing else like that yet. They just basically you know.
Okay, so you just got to get. They just made a date on you, right? And the reason why they did now, that's the right thing they're supposed to do, because whatever that was, there was no warrant to even have you charged. So, before they even talk to you, so they'll give you an opportunity to come back. Jurisdiction. That's why they made another court date, because there was no jurisdiction there.
And I actually pretty much I'd be on the show often. I'm not gonna say all the time, but often. My name is Akeem the Dream. When I do
okay,
make questions
I see that
in the queue.
Mm-hmm.
So I already basically challenged I haven't challenged the jurisdiction word for word, but I basically challenged the case by telling them that they ain't had no verified complaint, and then the judge basically told me that he didn't accept my verbal motions, but he was like, just write a motion and whatnot. But I didn't do that at the time,
and I was just planning on doing it. You should always. Your real fight is always in the paperwork. Your word can get lost in translation. You gotta respond by way of paperwork, and then you put your own affidavit in, stating facts. That has to be rebutted. So you'll have a sworn affidavit in, and they don't.
So I could put like a motion in to challenge the jurisdiction and an affidavit.
Yes.
Like that. Same time.
Yep.
And that would be the same. So I can basically do that like I would have done originally with this at the situation now that I actually missed one. Because I think that they might have did it like that instead of putting a warrant out immediately. I think they might have did it like that since he already kind of spoke with him. Maybe he already kind of knew. But I don't know.
You put your affidavit. My name is such and such, and I'm of the age majority, or I'm competent, and such, and you affirm all of that under oath. And
what would be the point that I'm making?
The point is making who you are. You're not a U.S. citizen. You're not. This is your name, but not that. And then state some. You definitely need to get into the matter of such and such happened at such a time. There was no warrant present. Blah blah blah. Whatever your argument is, you want to put that into that affidavit. You just went to the fact that you would question, like me. Say if it's attracted, I was stopped. I would use terms like I was pulled over. I didn't understand why I was being pulled over, but this is what happened. I state what happened, and everything I state is the officer proceeded to ask me questions without a warrant. He asked for information, but did not have a warrant. He did not read me my rights. I would be saying I'd state all of the facts of what happened right there.
So basically, how you open up the show,
still jurisdiction. Say it again.
So how you open up the show today? Basically, if I was to state the facts of what happened, making sure that everything that I'm saying is like something that he needs to rebut. They're not going to rebut probably. Right. But if I
you can't rebut the fact that he didn't have a warrant. How are you going to rebut that he didn't have one? He said, well, I have probable cause. But even if you have probable cause, you still need a warrant. Say if you get arrested, right? Do you know they have to have a warrant to take you off to jail? A judge has to approve that. So until you get to get you in jail, there must be a warrant to have you in jail, and then that means you're under custodial interrogation, like I just read earlier. And then
that's what I was listening to.
If they decide to arrest you, they gotta get the approval. I'm gonna arrest them. I'm taking to jail, and they gotta get a warrant to have you in jail. A warden cannot take anybody into their charge unless there's a warrant for you to be there. So you need a warrant for arrest and a warrant to be incarcerated. You need an order. Some type of order to say that. Yeah.
I got one more question. I got another separate case that's been basically looming around for like almost 5 years now. They just basically leaving it in limbo.
Mm-hmm.
I challenged a couple things in it, simple things, but they didn't even basically hear them. But they just ignored it. But now they just sent me something about a jury trial out of nowhere. But the thing is, during one of the court dates, I was on the way up to court, and I was talking to like some clerk, not even an actual person having anything to do with the case. I was emailing them back and forth, letting them know that I was going to be there, but I was going to be a little bit late, whatnot. So I get there like 5-10 minutes late, and I could tell that they didn't even hold court that day because the courtroom was all closed up, everything like that. So it wasn't even possible that they held court that quick. But long story short, a bailiff came up there while I was looking at other courtrooms just in case I missed the wrong courtroom or whatnot. He acted like he didn't have nothing to do with nothing and walked past me. And then once I walked past him, he turned around and grabbed me and locked me up, basically. So I started telling him, like, I got the right to be informed what I'm getting locked up for. He said, I don't want to hear none of that. They locked me up. They kept me in there for a day. They put a bench warrant out, basically, for missing that court date for that day, even though it was like 5 minutes. And after I got locked up, they didn't, the date and time on the bench warrant wasn't issued until after I was already locked up for like 30, 45 minutes. So I know for a fact that that's a false arrest. And I know for a fact that was illegal. But I'm thinking, I don't really, I'm not an expert in anything like that. So I'm trying to figure out, to do a counterclaim, would I put something into the actual case that's going on, or would it be a whole separate?
You can do it. A counterclaim means you're gonna put a counterclaim into the case that's going on. If you're gonna do a counterclaim, that's like if you being charged with something, or even if you're being sued, you do a counterclaim. It's right there in the same case. That's what a counterclaim means. You think that would even be
a course of action for something like that?
I can't give you. I can't tell you that because the information you're giving me is not enough for me to base a good decision on. Give you a good answer. But the story you just told me has a lot of missing pieces, and you know it. You just gave me like this, that, and the other. You didn't give me the whole thing. There's a lot of moving parts. You're not telling me, so I can't give you an answer off of that.
Yeah, I mean,
right? So if you want to really go into it, you don't want to go into it on the phone like this. I appreciate that. I understand that. You need a private consultation. Private consultation. Then I need to see. See, I have people telling me everything, and then when I look at the paperwork is saying something totally different than how they interpret it. People interpret things the way they want to see it, not how it is. And that happens 99.9% of the time when I'm talking to people and they're telling me this and they're telling me that. And then when I get that paperwork in front of me and I read it, and I'll be like, this is what it really is saying here. So I need more information before I can answer that one. It's a lot. It's very convoluted with the story, and it's missing some key information.
I just say it kind of weird.
Well, not that you said it weird. It's just what you said, and it's missing parts. It's missing some really vital information.
Important, pertinent.
Yes.
Basically, I got called down there for like a bunch of status conferences because every time they called me down there, they didn't have I don't know what a officer was. He was disappeared or something like that. But I got called down there for like 10 status conferences back to back, like months and months apart.
They
And
do
then,
that. They do that
one
because
time
they
I challenged-
overcrowded with they overbooked with cases. So that's like common. You know.
Yeah, I tried to quash the whole. I tried to quash the whole thing. I stood up in
See
court,
that?
tried to quash it, and then the judge.
See what I'm saying? See that right there? What you just said? That's a big piece.
Yeah.
How did you quash it? What did you say? What did you write? And by what you're telling me,
I didn't write it.
Your procedure, see that right there. Your procedures are off. You're
No, I
just
know that.
wanting.
I know
You're
that.
just telling them, man. Talk to you. don't have no paperwork in. But yeah, brother. I gotta move on.
We didn't even hear it.
Yeah, I gotta move on. You're gonna have to do a private consultation. I need to see details. That's not enough for me to say anything.
Gotcha.
All right, peace, bro. All right, you have a good night. All right, y'all. That's it. Okay, I wanted to address something. Yeah, judges cannot practice law from the bench, and when they try to hand you an attorney and try to get someone to they're practicing law. They're speaking for you. They're creating contracts for you. They're telling you they're giving you legal advice when they tell you that you get here's this lawyer. And I know it's a common practice, but when you really look into it, it's bull. All right, y'all, that is it. For me tonight. So, with that being said, remember, don't be double-minded. You guys got aspirations, you got goals, you want to be great, you want to be wealthy, whatever it is you want that's positive, know you're going to get it, see yourself having it, and don't doubt it. All right? Remember, you're the God in your life you're looking for. You're the Christ. You are God. Peace.
Peace to the gods. You're listening to Hindsight Radio. station, changing the nation.